President Trump's relentless attack on gender-affirming care and healthcare providers in our states. This time, the attack comes in the form of two cruel, inflammatory, and unlawful executive orders and follow-up actions U.S. Attorney General Pam Bondi and her team have taken to block gender-affirming care for individuals under 19 years of age and threaten healthcare providers' licenses, livelihoods, and liberty. Trump, Bondi, and their allies have undermined trained medical professionals, trampled over states' rights, overstepped their constitutional authority, and endangered vulnerable minors and 18-year-old adults. Our coalition of 16 Democratic attorneys general and one state refused to stand by and allow Trump, Bondi, and the administration to break the law, harm patients, and violate our rights without a fight. Before I get into the specifics of this case, I want to acknowledge that none of this would be possible without the partnership of this coalition of AGs and each of our incredible legal teams who work tirelessly to ensure every person in America, regardless of how they identify, has access to medically necessary health care. At California DOJ, that includes our healthcare rights and access section, which I'm very, very proud of and helped us get to this point today. Let's talk more about what led to our lawsuit. By the way, the 37th lawsuit my office has filed in 27 weeks. Shortly after Trump took office for his second term, he issued two executive orders that used cruel, demeaning, and inflammatory language designed to harm transgender people and undermine the legitimacy of their medical care. Since then, US DOJ, led by Attorney General Bondi, have issued two directives that outline the steps the department is taking to block access to gender-affirming care for patients under 19 years old, including 18-year-olds who are legal adults in California with the right to make their own healthcare choices. The directives misleadingly referred to gender-affirming care as fraud and exploitation and ordered the federal DOJ's Civil Division to use all available resources to investigate doctors, hospitals, and others providing it, rather than spending their resources on going after elder fraud, cyber fraud, fraud against members of our military, or any number of examples of actual fraud and exploitation. They put their might behind going after doctors and medical providers just trying to do their jobs. US DOJ has subpoenaed more than 20 doctors and clinics and threatened other providers and healthcare institutions with civil and criminal prosecution if they provide scaled back or stopped providing gender-affirming care altogether out of fear of retribution, denying countless patients the medical care they need and are entitled to. Trump and Bondi have no legal ground to stand on. There is no federal law in our country prohibiting gender-affirming care. In fact, California and the other states represented by this lawsuit have laws protecting the right to gender-affirming care. California recognizes gender-affirming care as medically necessary healthcare and prohibits healthcare providers from discriminating against patients on the basis of gender identity. Strong-arming doctors and medical providers to deny this medically necessary care is not only unethical and dangerous, it's also illegal. While Trump and the Republican Party love to tout the importance of states' rights, they're actively trampling over ours. For more than 135 years, states have had the legal authority to regulate the medical profession within their borders, a right that's protected by the 10th Amendment of the U.S. Constitution, and that's been upheld by the courts. Trump and Bondi are breaking the law, violating the Constitution, and harming our people, which is why we're taking them to court again. Trump and Bondi are not trained medical professionals. They aren't at all qualified to give anyone medical advice. What's worse, they refuse to listen to the actual experts. There's substantial medical research that shows gender-affirming care improves the symptoms of gender dysphoria. Gender dysphoria is a serious medical condition that results in significant distress when one's gender identity doesn't match their sex assigned at birth. Left untreated, gender dysphoria symptoms can include depression, poor self-esteem, substance use disorders, and an increased risk of self-harm and suicide. Medical providers are trained and qualified to identify and treat gender dysphoria, including considering gender-affirming care. Trump and his allies have very intentionally politicized the conversation around gender affirming care with despicable, incendiary language in order to stir up fear, confusion, and hate. Let's be clear about what gender affirming care for adolescents really is. In the majority of cases, after extensive evaluation and a diagnosis of gender dysphoria, gender affirming care may include puberty delaying medication and or hormone therapy. It rarely includes surgery for minors. Forcing adolescents to wait until they're 19 to access this medically necessary care is extremely harmful, as it allows the serious symptoms of gender dysphoria to continue and worsen as time goes by and as they go through puberty that doesn't align with their gender identity. Not to mention that forcing young people to wait also denies them the opportunity to grow up and fully experience life with their friends and their peers as their most authentic selves. Decisions around gender affirming care are made with the same care, caution, compassion, and medical oversight as any other healthcare decision for individuals. And when the patient is under 18, it's done in consultation with parents or guardians. This is a decision between patients, parents, and providers. Patients, parents, and providers, not the president, not politicians. While the Trump administration may claim this isn't an all-out ban on gender-affirming care, the chilling effect it's created has greatly affected access to health care. The administration's threats to providers' licenses, livelihoods, and liberty have caused them to abandon their patients and their responsibilities. The chaotic directives and threats of civil and criminal prosecution have left hospitals and clinics confused and concerned, causing them to abruptly and unlawfully end care. Unfortunately, right here in California, Children's Hospital Los Angeles, the largest provider of gender affirming care for minors in our state, has allowed itself to get caught in the crosshairs of Trump's attack. For more than 30 years, CHLA has been a leading provider of high quality, evidence based essential care for transgender young people. On July 22nd, CHLA completely shut down their Center for Trans Youth Health and Development and ended care for nearly 3,000 patients because of, quote, risks stemming from the shifting policy landscape, end quote. The shutdown came despite efforts my office took over recent months to assure CHLA that they were protected and required to provide gender affirming care. As one parent of two longtime CHLA patients told us, this closure will be, quote, life and death, end quote, for trans youth who can no longer get the care they need. Life and death. Blocking gender affirming care for young people is just one prong of Trump's campaign to erase the existence of transgender individuals, scare them into the shadows of society, and deny their rights. Since taking office, Trump has issued 8 executive orders and a raft of federal actions that relentlessly target one of the smallest, most vulnerable communities in our nation. Ending medical care, politicizing bathrooms and youth sports, banning them from serving our nation in the armed forces. Trump's attacks on our trans community are cruel, illogical, and in the case of today's lawsuit, illegal. Today, my office is releasing new guidance to help California providers, patients, and families understand their rights and protections under the law. You can go to our website to have a look at that. For any California provider or institution who is confused, let me be very clear. California law has not changed. Equal access to healthcare services, including gender affirming care, is the law in California. Gender affirming care is and will continue to be a protected right for our transgender community, period. As Attorney General, it's my job and honor to protect the rights and safety of all people who call California home. That will always include safeguarding transgender youth and healthcare providers who provide gender affirming care. Fortunately, I don't stand alone. I stand side by side with my colleagues, and I stand. Indulge me as I recognize the team: Hillary Burke Chan, Nimrod Pitzger Elias, Crystal Adams, Katie Milton, Kathleen Borgers, Nellie Pama. Thanks to all of them for their great work, all hardworking, incredible servants. With that, it's now my pleasure to turn it over to my friend and colleague.
Thank you, General Bonta, and thank you, General Wool, and all of our fellow attorneys general and states who are part of this, and Governor Shapiro of Pennsylvania and the state of Pennsylvania, the Commonwealth of Pennsylvania. And let me also join General Bonta in thanking our staffs and our teams for doing all of the hard work it takes to get to this point as we file this lawsuit to protect children and families in our states and commonwealths across the country. Let me just um, let me just start by saying there's going to be a lot of talk as we file this case and prosecute this case about rights, about the rule of law, about healthcare. But at the end of the day, this is about people. It's about families and it's about children. General Bonta and General Raul and I share a number of things in common. We are state attorneys general and we're also former state legislators. But the three of us, most importantly and principally, are husbands and dads, and we're parents. I have three kids, 19, 17, and 14. And the question I have for the president and the attorney general and anyone who wants to attack children and families and healthcare and transgender people and gender affirming care, my only question is, what would you do if your kid, your child was diagnosed with gender dysphoria? I know what I would do. I would fight for my kid every single day. And that's what we're doing right here. We're fighting for kids and families in our states and our jurisdictions, parents who just want to do the best for their kids, as we all do, to help them live their best and truest lives, but also to treat a medical condition called gender dysphoria. That's all they want. They want health care and they want their kids to be safe. I'm one of the first legislators when I was in the state legislature here in Connecticut. I was one of the first state legislators to vote for a law codifying the rights of transgendered people here in Connecticut. One of the first laws in the nation, anti-discrimination laws, to recognize and protect transgender people. And that, I will tell you, was not an easy effort. There was a lot of confusion. People didn't have a lot of information and knowledge. And it was a difficult debate and it was hard to get there. But we've learned a lot since we first voted for that law. I think before 2010, it goes back a number of years now. And we learned about gender dysphoria, and we learned from medical experts, including every major national medical association, who have determined together as a medical and scientific community that gender affirming care, that the health care that is provided, including the medication that is provided, is medically necessary, and that people need it not just to live their truest selves, but to live, to survive. And without this medical care, we run the risks of depression, anxiety, severe mental health implications, self-harm, suicidal ideation, and worse. And so this isn't just about healthcare, but it's also about the consequences of not providing that healthcare. I remember during the debate over Connecticut's non-discrimination law for transgender people that legislators on both sides of the aisle struggled, including my fellow Democrats. First on the Judiciary Committee, where I served and was later chairman, and then in the broader General Assembly. And I remember asking a state legislator for his advice. And I asked him how he thought about this issue. And he said, William, the basic question you should ask yourself is, as a legislator, are you in the business of discriminating against people? And the answer is simple. No, I'm not. And neither are we. And we are going to fight to protect children, families, parents, our non-discrimination laws, and we are not going to allow the President of the United States, the Attorney General, to use, contort, pervert the law to discriminate against people. We come to this action with a great deal of sadness today, because even though we step forward confidently, strong, we know that our lawsuits this lawsuit is going to be successful and we're confident in our legal position. We are sad because people are getting hurt right now. Children are getting hurt right now in our jurisdictions. Care is being transitioned away from them or cut off, and people are really going to suffer. And that's why it's so important that California, Illinois, Connecticut, and all of our coalition states stand up today, push back, and be a firewall for transgendered youth, transgender kids in our jurisdictions, and to be a firewall for all American families. And with that, it's my honor to turn it over to my now longtime colleague and fellow Attorney General, the Attorney General of Illinois, Kwame Raoul.
Uh, Thank you, William, and thank you, Rob. Well said. This is about saving lives. Since taking office, President Trump and his administration have relentlessly, cruelly, and unlawfully targeted transgender individuals on multiple fronts. The assaults on the rights of transgender people include a push to deny them necessary health care through an unlawful executive orders and a steady drumbeat of federal actions. Baseless threats of civil and criminal prosecution have led to Illinois providers pulling back on care altogether. This administration is driving a wedge between patients and healthcare providers from providing patients the healthcare that they need. These actions are causing chaos, confusion, and fear amongst medical providers. And they're also stoking anxiety and dread among transgender patients and their families. Federal law enforcement agencies, which have historically partnered with our office to protect children from violence and exploitation, are now targeting children's hospitals. Instead of going after violent criminals, federal law enforcement agencies are being directed to go after healthcare providers who offer a wide range of care to pediatric patients, from treating congenital disorders to childhood cancer. To do this, the Department of Justice is diverting valuable law enforcement resources away from catching criminals and predators who are actually harming children. How does any of this keep our children or our communities safer? Our lawsuit challenges recent federal actions targeting healthcare providers who offer medically appropriate care to transgender individuals under the age of 19, even in states like Illinois, where such care is legal and protected. The administration has overstepped its authority by using threats of federal investigation and criminal prosecution under laws that do not apply in this care. These threats have pressured providers to stop offering life-saving care. We are asking the court to block these actions and protect access to care for patients who desperately need it. The federal government's unlawful actions also interfere with the state's authority to protect and enhance the health and well-being of our residents. In Illinois, we have made it clear that seeking or providing health care for transgender youth and adults is not only lawful, but welcome in our state. This week, I hosted a town hall with some of my fellow attorneys general to hear from people in Illinois about how unlawful actions taken by this administration are negatively affecting their lives. At that event, we heard from farmers, educators, business owners, individuals, law enforcement, healthcare providers, and others. We also heard from transgender residents, including one who made the selfless and patriotic choice to serve our nation in the armed forces. We've heard directly from those impacted that the access to gender-affirming care is life-saving and allows people to live their authentic life. I'm proud to defend the rights of all transgender people to have access to health care that they deserve to live full and healthy lives with the same opportunities and autonomy as their friends and neighbors. I want to thank my staff and the staff of all the attorneys general who have risen to the occasion to fight for not only this action, but the multiple actions that we have taken against this administration. Thank you, and I'll give it back to Rob.
Thank you. We can take any questions that there might be from the press.
If you'd like to ask a question, you may do so now by hitting the raise hand icon at the bottom of your screen. You can also submit a question through the Q&A feature, also at the bottom of the screen. First, please state your publication when you ask your question. First question comes from Craig Wall. You're now unmuted.
Craig Wall with ABC 7 News in Chicago. This is for General Raul. What do you say to the hospitals, and we have 4 of them now, who have agreed to stop offering gender-affirming care? What should they be doing as your lawsuit winds its way through the court?
Well, yes, we've had recently a number of hospitals who have, under the threat from the federal government, made the decision to stop providing the gender-affirming care that they have for years. And so I do not cast a negative eye towards those healthcare providers who have been dedicated to providing this care for years, and that's why we're bringing this action today. In an effort to remove that threat so they can return to providing that care.
Just to follow up, would you encourage them to just stop or continue to put everything on pause until this lawsuit goes on, or would you encourage them to be bold and go back to offering the care that they had been offering prior to the pressure from Washington?
Craig, my job is not to make the decision. I'm not the CEO or administrator of a hospital, but my job is to try to remove the unlawful threats to those institutions that provide life-saving care, not only for transgender individuals, but for all sorts of children who have all sorts of illnesses. It's unconscionable that the federal government would threaten such institutions that attempt to save the lives of our children.
Thank you. Next question comes from Kevin. You are now unmuted.
This is Kevin Rector with the Los Angeles Times. Attorney General Bonta, the LA Times recently reported that the Trump administration's appointee to U.S. Attorney in Los Angeles, Bill Asaley, had floated the idea of criminally prosecuting medical providers for providing gender-affirming care. I know that a lot of people in the LA region, including families with transgender children, are fearful that prosecution may play out. Families have expressed fear to the LA Times that not only will medical providers be prosecuted, but potentially parents will be prosecuted as well. They worry that their family's medical information had been collected under those subpoenas issued by the Justice Department. I'm wondering if you are in communication directly with Asaley's office or directly with hospitals or parents about what type of information has been collected and where Asaley's office is in its thinking about proceeding with this type of prosecution potentially.
Thanks, Kevin, for your question. We are certainly aware of the press release from the US DOJ about 20 different criminal subpoenas being issued, very aware of the facts and the reporting on the criminal subpoenas issued to Boston, Denver, and LA Children's Hospital. So the idea of issuing criminal subpoenas is not an idea. It's been done. It's happening, and the potential for Mr. Asaley or anyone else in the U.S. Department of Justice issuing more in the future, consistent with and in continuance of the efforts already commenced, um, should be expected and would not be a surprise. They are definitely trying to chill and coerce and bully and intimidate with threatened criminal prosecution. So they are definitely waging the culture wars. They're definitely playing politics. What they're not doing is practicing law. The basis for any criminal prosecution is non-existent. It is if you just take one look at the law and the federal female gender mutilation statute, it exempts. It doesn't even contemplate medical care. It is for non-medical procedures. What we're talking about is medically necessary care being provided by licensed medical professionals. So not even anywhere within the female gender mutilation statute. And similarly with the Food, Drug, and Cosmetic Act and the False Claims Act. I mean, these are like the reaches of the worst kind. You have to do mental gymnastics and somersaults and mutate and manipulate existing law to even think it comes close to prohibiting gender affirming care. As I mentioned earlier, there's no prohibition against gender affirming care. So having said that, and making clear how weak the federal and really non-existent the legal basis for these federal prosecutions are, I understand the fear. I understand it. I understand hospitals being worried anytime you get a criminal subpoena from the federal government. You take note, and it has an impact. And I understand for parents as well. Um, we haven't heard of any targeting of parents at this point, but it's been towards providers, hospitals, and even specific providers potentially, um, including surgeons who provide gender affirming care. But it doesn't mean that they won't. If they're willing to use non-existent law to attack providers, what would stop them from going after parents as well as they wage these culture wars? So um, I, I leave nothing, uh, beyond the possibility for this administration. It is not responsible. It is not good faith practice of the law. It is bullying and coercion of the worst kind. But we've definitely been in contact with families and patients. I talked to you in my opening remarks about what we heard from one parent of a CHLA patient and how this is a life and death situation. We're in touch with all the providers. We don't converse with Mr. Asali. We're going to converse with him through our legal filing today to make our position known and ask a court to provide the relief that we need.
Thank you. Next question comes from Kristen. You are now unmuted. You have to unmute yourself as well.
Oh, I'm sorry. Thank you. Thanks for taking the time. I'm Kristen Schorsch. I cover healthcare at WBEZ Public Radio in Chicago. Attorney General Raoul, thanks for taking the time to do this. I just wondered, what do families in Illinois do in the meantime, as we now have 4 major hospitals that have cut or scale back care? I mean, this is affecting hundreds of kids. Some are going to private providers, but still these major hospitals where we're treating so many people. So I'm just wondering what the message is to families as this winds its way through the courts.
Well, my message to families who I've personally met with in my office is that what I will do with the powers of my office is to move to remove the threat. Again, as I said to Mr. Wall, I am not a healthcare administrator. I am not head of a hospital that's being threatened with potential criminal investigation or prosecution or removal of funding that goes towards saving the lives of various patients. And so I'm not in the position of either advising what administrative decisions should be made at hospitals. To the families, I say, and I have said, I will do everything in my power to try to remove this unconscionable threat that's coming from our federal government.
Can I just ask one quick follow-up? I guess I just want to understand. I've talked to a lot of families and advocates, and they still just don't understand why hospitals have been able to scale back gender affirming care, considering we do have a state law in the books banning that discrimination against patients based on gender identity. So, can you explain how hospitals are able to legally do this in Illinois with the Human Rights Act on the books?
There are hospitals that provide gender affirming care historically, and there are hospitals who have not provided gender affirming care. There are hospitals that provide certain type of care in other areas, and there are hospitals that do not provide other kinds of care. There's nothing on the books that mandate that hospitals provide all medical care that's available. And so those administrative decisions are made on a case-by-case basis by all hospitals. There are doctors that are providers in certain specialties. They don't provide care in other specialties. Our law does not mandate that all doctors, all providers, or hospitals provide all care.
So it's not discrimination if a hospital decides to stop providing that care.
I don't believe it's such, particularly if you have the federal government threatening you with criminal prosecution or removal of funds that is critical to providing life-saving care. I don't know what you would do.
Okay, thank you.
Next question comes from Aaron Bolton. You are now unmuted.
Yeah, hi, Aaron Bolton with Montana Public Radio and covering for NPR today. In your ask for relief in this case, do you expect this, if you were granted that by the court, do you expect this would apply nationwide? Here in Montana, gender affirming care has also been protected by the state Supreme Court, but our last hospital ended gender affirming care, forcing patients to travel out of state. Do you expect relief to apply to states like Montana as well if you're granted it?
Maybe I'll take a crack at that. The states that are parties to the case today certainly will get complete relief should we prevail. And we're seeking a declaratory judgment that says that the three laws that the federal government relies on, the female genital mutilation statute, the Food, Drug, and Cosmetic Act, False Claims Act, that they do not prohibit the provision of medically necessary gender affirming care. And we think that that is not a close call. In fact, a judge in Washington already said as much in an earlier case in a very different posture. So we at a different time. And so we believe that declaratory judgment will certainly help in all the states who are parties. It could also potentially help in the states that are not parties, that have not decided to bring a lawsuit at this time. So, but because of that CASA case that arose out of our birthright citizenship case and the requirement that only parties who bring the case can get complete relief. Sometimes that relief can be in the form of a nationwide injunction, by the way, like it is in our birthright citizenship case. But states who are not parties to this case are at more risk of not getting the relief. Those who brought the suit, like the ones in this press conference, will have the full relief.
And just quick follow-up, can you say how states that are not parties might get partial relief, how this might help in those places?
Well, for Montana, for example, should we get a declaratory judgment from this court in the District of Massachusetts stating that there's no basis for the executive order that we challenge and the actions that carry it out, Um, they could cite to that in any motion to quash a criminal subpoena or any legal proceeding, and it would be persuasive. And I think it would be very persuasive because it's a clear legal question, but it wouldn't be as directly applicable as it would be for the parties who seek and secure the judgment from the court in the District of Massachusetts.
Thank you.
Next question comes from Greg Bishop. You are now unmuted.
Right. Thank you so much. Now, understanding you guys aren't medical doctors and are attorneys, curious your thoughts on what could possibly happen in the future with medical science. Lobotomies used to be accepted from the 20s to the 50s, fell out of favor, and now kind of viewed as barbaric. What happens in a couple of decades if the science changes on what is considered gender affirming care and the use of hormones might be considered detrimental? How do you address that down the road with this issue?
Well, Greg, as you said, neither of us are medical professionals, but there are medical professionals and there are medical organizations who have all stood by the science of gender affirming care. The American Academy of Pediatrics, the American Academy for Child and Adolescent Psychiatry, the American Medical Association, the American Academy of Family Physicians. Those are organizations amongst many others who are organizations populated by medical professionals and who rely on science of today. And our action is an action for today, and I don't anticipate that medical science changing.
And I apologize for not announcing the organization with the Center Square and Illinois Radio Network. Just to follow up on that, have you heard from those who have gone through gender affirming care that are opponents of it? I think they consider themselves detransitioners. Do you take into account their concerns in this conversation as well?
I have not heard from them.
Thank you.
Thank you. Next question comes from Alex Cohen. You're now unmuted.
Thank you so much, and thank you all for taking the time today to talk about this. Two questions, if I might. For all of you, as you well know, this issue of gender affirming care, which the current administration has invested a lot of time, money, and energy in, was ultimately unsuccessful when it came to the Supreme Court level. And I'm curious if you take anything away from that experience as you pursue your actions. And Attorney General Bonta, given some of the recent remarks that Governor Newsom has made about gender affirming care and his uncertainty, maybe your uncertain feelings about it, have you had the chance to discuss this lawsuit with him? Thank you.
Thanks, Alex. I think on the U.S. Supreme Court case, maybe you're talking about the Skermeti case, which came down a few weeks, maybe over a month or two back now. Disappointing case, of course. It allowed states to not provide gender affirming care if that's what the state decided. We believe that that's in California, that's discriminatory. It violates the Equal Protection Clause. Was wrongly decided. It does allow for states to make their own decisions about providing gender affirming care. California has made its decision. We're providing gender affirming care. It's protected. So it's an interesting, actually, affirmation of 10th Amendment states' rights in that U.S. Supreme Court case that Bondi and Trump, again, not doctors, not medical providers, no medical expertise, have decided to try to trample on that 10th Amendment right of states like Illinois and California, who do want to provide gender affirming care consistent with medical consultation, advice, and recommendations. So we disappointed in that case, of course, but understand that it's the U.S. Supreme Court's decision, and in California we respect court orders and we'll follow them. But that court order does not change anything in California because it allows states to make their own decisions about the provision of gender affirming care. And again, California is a state that will be providing it along with Illinois. I don't know if the governor has made any statements about gender affirming care. Maybe you're referring to his statements around transgender athletes. Those
He
are his
did make
personal
those
opinions.
remarks as well. He appeared recently on another conservative podcast where he brought up the Cass report, which we heard similar concerns alluded to earlier, even though their major medical organizations have discredited it. I believe his words, not verbatim here, was something along the lines of, there are various reports, it's hard to know what to believe. So I was just curious if you would discuss this with him at all. Thank you.
The governor is engaged in podcasts in his personal capacity. It's not his official capacity. He's entitled, of course, and he's expressed his personal opinions. And I understand it, and I respect his right to his opinion. We have, as with, I think, all of our cases, been in touch with the governor's office about the cases that we bring, the basis on which we're bringing them. So our bringing of this case today will be absolutely no surprise to the governor. He and his office are fully aware of it.
Thank you. Next question comes from Craig. You are now unmuted.
Thank you. This is just a follow-up with Attorney General Raul. I've heard from General Bonta that there are a number of states where subpoenas have been issued either to medical professionals or to parents. Are you aware of any action like that being taken here in Illinois? And if so, do you know which hospitals those medical professionals might be associated with?
I'm uncertain as to the answer to that question. I know that this is taking place certainly in other jurisdictions, and certainly there's a broad threat of through these directives towards these institutions, whether it's the Bondi directive or the Schumett directive, and whether or not subpoenas have issued, just the directives themselves provide a threat to these institutions, in addition to the threats of removing funding. Additionally, to the previous question, I believe General Bontas stated it well. The Scarmetti decision does not have a negative impact on this decision. And in a strange way, it buttresses it because one of our claims is about our state's rights, our 10th Amendment right. So in Illinois, gender affirming care is lawful and protected.
Thank you.
And next question comes from Ashley. You are now unmuted.
Hi, my name is Ashley Zavala. I'm a reporter for KCRA3, the NBC affiliate in Sacramento. This question is for Attorney General Bonta. I know this is lawsuit number 37, and this is your third press conference this week. And I just wanted to follow up on something you mentioned during lawsuit number 35, that you intended to ask. I know the California legislature and governor have appropriated you $25 million. You've used $5 million so far, you pulled $5 million. You mentioned a multi-million-dollar request to draw down further. Do you have a specific number that you can share there? And just if you could speak to just the magnitude of the work that you've been undertaking over the last 25 weeks or so.
Sure. It's in the double digits, the additional requests that we'll be making, double digit millions, sorry. So it's over 10 million. I don't have the exact number at the ready, but it's more than the initial 5 million. And it reflects the work that we've done in bringing 37 lawsuits in the first 6 months. And so the way that the funding works is you draw it down as you use it. And so we're going to be submitting a request for funding based on the work that we've done. So I wish I could be more specific, but I'm giving you a general sort of estimation of how much it'll be. It'll be significant. It'll be more than the original 5 million. It'll be in the double-digit millions, and it reflects the work that we've done and the work that the legislature and the governor wanted us to do and funded us to do. And of course, I always want to make sure that while we talk about the costs and our work has costs to it, we also talk about the benefits and the return on investment. And I've mentioned this before, but I want to make sure I mention it as I answer this question. We have protected billions of dollars, approximately $170 billion in funding that would have been stripped away and taken away and withheld from California, if not for our lawsuits. So the 5 million plus the additional amount that we seek a drawdown for, that amount pales in comparison to the massive return on investment that we've had. Those small and modest investments relatively have led to massive returns on investment in the hundreds of billions of dollars, 170 billion to be specific. So that's what the California wanted us to do. We're doing it. We're largely being successful, protecting funding and protecting California's rights and freedoms as well.
Thank you.
Thank you.
And that is the final question.
Thank you. Thank you again to AGs Raul and Tom for your partnership and your leadership. I'm sure we'll be seeing you all again soon, but thank you for joining us today. Thank you.
Who wants to pull another all-nighter? Who's gonna review a ton of evidence? You? No! Cecilia is. Behold, Disco's new AI assistant. Hear it hum. This weekend, have a weekend! Beast.
Elevate your game this season at Dick's. Score the latest gear from the best brands for football, soccer, volleyball, and more. Plus, choose from thousands of cleats from Nike, Adidas, Jordan, and other top brands. Shop in-store or Dicks.com to make it your best season yet.